All right, we are ready to go on the record. Good morning, ladies and gentlemen. My name is Michael Caruso. I'm from the Department of Environmental Conservation's Office of Hearings and Mediation Services. I'm the administrative law judge assigned to conduct this issues conference in the matter of CPV Valley LLC, an application for an air state facility permit renewal. The Office of Hearings and Mediation Services is a distinct unit in the Department of Environmental Conservation and is separate from Council's office, the various program units, and the regional offices. The sole purpose of the Office of Hearings and Mediation Services is to conduct hearings such as this one. This administrative hearing is being held pursuant to Articles 19 and 70 of the Environmental Conservation Law of the State of New York and Part 624 of Title VI of the Official Compilation of Codes, Rules, and Regulations of the State of New York to consider the application filed by CPV Valley LLC for the renewal of its air state facility permit. CPV's renewal application dated January 23, 2018 was received by Department staff on January 24, 2018. On August 1, 2018, Department staff advised CPV that its air state facility renewal application was denied because it failed to satisfy, as a matter of law, all applicable regulatory requirements. In particular, the department stated that the regulations require owners and operators of a new facility subject to permitting under 6 NYCRR subpart 201-6 to obtain a Title V Clean Air Act permit prior to operation of the facility. By letter dated August 2, 2018, CPV requested a hearing on the department's denial. CPV has taken the position that the air state facility permit conditions provide that this CPV is to apply for its Title V permit within 1 year of commencing operation. CPV further argued that notwithstanding the department's denial that the air state facility permit continues until there is a determination of this matter pursuant to SAPA 4012 and 6 NYCRR 621.11L. And today's proceeding was referred to as an issues conference. And participation is limited to the applicant, staff from the Department of Environmental Conservation, and those who have filed timely petitions for party status or for amicus status. Petitions for party status were required to be received by my office no later than 3 p.m. on October 5th, 2018. I received 2 petitions, one from Pramila Malik on behalf of Protect Orange County, and one from Jenna Elston. The issues conference notice was published in the Environmental Notice Bulletin on November 14th, 2018, and in the Times Herald Record on November 16th, 2018. Applicant has provided me with a copy of the affidavit of publication of the notice in the local newspaper. A stenographic proceeding of today's proceeding is being made. Stenographic record of today's proceeding is being made. I've asked the stenographer if she cannot hear you or you're going too quickly to signal me or you and ask you to slow down and speak up. It's very important we get everything that everyone says today on the record. And I'd like to start out. Can I get appearances for the record, please, starting with the applicant?
Yes, Ruth Leyston Snyder and Dana Stanton from Nixon Peabody.
Thank you. Staff?
Mark Sanza. Kai Gibbs.
Thank you. Ms. Heather?
Pramila Malik on behalf of Protect Orange County.
Thank you.
Gina Elston from New Hampton, Waybound.
Thank you. And we currently have 2 parties, which is the applicant, CPV Valley LLC, and DEC staff, and 2 petitioners seeking party status. I ask each of you to designate 1 speaker. I will recognize the speakers to control the record and keep people from talking over one another. Please speak loudly, slowly, and clearly. I also ask that you respond directly to my questions, and please stop speaking when I'm trying to interject. The purpose of today's issues conference is as follows: to identify points at which there's a legitimate controversy that bears on the department's denial of CPV's permit renewal application. Second, to identify issues raised by petitioners and discuss whether the issues meet the standards for adjudicable issues. And to provide the applicant and DEC staff with an opportunity to respond to the petitions of Protect Orange County and Ms. Elston. I review the permit renewal application, DEC's denial of the application, CPV's request for a hearing, and the petitions of Protect Orange County and Ms. Elston. I want to be sure I understand each party's and petitioner's position related to the issues raised. So this is going to be a question and answer session where I ask questions of the parties and petitioners, and you will provide the answers, okay? So I'm going to start out. with Protect Orange County. And I have your petition here in front of me. So my first question, Ms. Malik, is Protect Orange County seeking full party status?
Yes.
Thank you. And looking at your petition, what is the issue you're raising?
Well, I was deferring somewhat to the comments that I made during the public comment period and comments made by members of Protect Orange County, but specifically we're very concerned about the health impacts that we have already documented from the operation of this facility. We have been compiling health symptom reports and emission event reports and odor event reports since January of 2018. Specifically, the plant began operations January 16th, and from that time period, we have had numerous reports of adverse health impacts. It is, I think, a matter of law that no facility, let me cite the law, 6 NYCRR 211.1, air pollution prohibited, no person shall cause or allow emissions of air contaminants to the outdoor atmosphere of such quantity, characteristic, or duration which are injurious to human, plant, or animal life, or to property, or which unreasonably interfere with the comfortable enjoyment of life or property, notwithstanding the existence of specific air quality standards or emissions limit. This prohibition applies, but is not limited to any particulate, fume, gas, mist, odor, smoke, vapor, pollen, toxic, or deleterious emission, either alone or in combination with others. Protect Orange County is prepared to provide first-hand testimony of residents who have experienced adverse health impacts that were linked directly to CPV operations. We will further provide testimony from public health experts who describe how the symptoms are related to specific pollutants that are emitted by this plant per their own air application permit. And health experts will also describe why the national ambient air quality standards and state ambient air quality standards and PSD standards are inadequate to protect public health. We will be providing both testimony as well as documentary evidence, which includes peer-reviewed studies and testimony from public health experts. That's just one of the many issues that our members raised during the comment period, and as you may recall, I referenced the entire voluminous record for this project, and I cited the DEIS, the town...
Let me stop you right
Sure.
there, because I have your petition in front of me.
Yeah.
Okay, your petition is talking about adverse health impacts, correct?
Yes.
Okay. So who's going to testify regarding the adverse health impacts?
The residents, members of Protect Orange County who are residents of...
And what are they offering for proof in that testimony?
They're offering their own experience, their own reports of odors that they experienced, and I think you can see when you see the testimony of people living in certain areas, you can see that the reports independently corroborate the reports of other individuals. So these are reports that were filed individually by various individuals, but you can see a pattern and a cluster when you put all that data together.
So let me ask you this about your residents that you're going to offer to testify. They understand that when they're on the stand, they're under oath, they are subject to cross-examination. I'm not going to speak for counsel for staff or counsel for the applicant, but that opens up their health history. If you're going to bring their health impacts into this proceeding, it's going to open up during cross-examination potentially all their previous health issues and their personal habits. So I just want to make sure it's clear.
Right.
That's what can happen.
Right,
Okay.
and we will make sure that whoever is willing to testify is made aware of that.
And who are your public health experts?
Our public health experts would be Dr. Dave Brown, Dr. David Carpenter, Dr. Celia Lewis, and Dr. Beth Weininger. And they are from the Environmental Health Project and the Yale School of Public Health.
Okay, thank you. How is your proposed issue a substantive issue?
It is a substantive issue because, as you can see from the regulations, there is no permit that allows injury to human health. If indeed the emissions from this plant are causing injury to human health, then that information is substantive, and it is in violation of both state and federal law.
Thank you.
Right. I mean, there are also several, procedural issues of process. One of the things I talked about in the comment was
Well, I'm not here to discuss comments. I want to discuss your petition. I want to stay focused on your petition, okay?
Okay.
Because there were many public comments. We had several, we had 30 or 35 during our morning or afternoon and evening sessions. We received hundreds and hundreds of emailed comments and mailed comments, and I've been through all those. So I want to really focus on your petition.
Well, my petition defers to all the issues that I have raised in the record in this matter, and I have raised many over the years.
Where in your petition does it say that?
I thought that's the whole point of this hearing, is to raise the issues
No,
that.
the purpose of this issues conference is for me to look at the petition you submitted and determine whether the issues raised in the petition, not all the public comment or whatever's happened beforehand, what you raised in your petition, are those issues substantive and significant? So I'm really limited to looking at your petition. I can't go looking at all, the public comments are fine. They're part of the record in these proceedings.
Okay.
But if we're going to establish a record for an adjudicatory hearing, it has to be based on things that are raised in your petition. Otherwise, DEC staff and applicant have a moving target. They need to know the purpose for submitting a petition so they know what the objections are to their permit or to a denial of a permit, whether you support that or not. But that's the purpose of the petition, is so they know what they need to address. They can't be expected to be addressing things on the fly, because that's not fair to them. It's not fair to the whole process. So let me ask you this. So in regards to your health issue, how is that issue significant?
How is human health significant?
Well, you're required to demonstrate your issue is substantive and significant pursuant to our regulations. So
Well,
I'm asking you, how is it significant?
If someone is experiencing respiratory problems to the point that they have to go to the hospital, or they have to seek medical assistance, if somebody is experiencing rashes, burning throats, burning eyes, which are some of the many symptoms that our members had described, that is injurious to human health, and it does indeed interfere with the comfortable enjoyment of life and property, and it is prohibited as a matter of law. And so it has to be evaluated and determined whether, despite compliance with NAAQS and PSDs and the air quality standards, whether there is still, despite that, injury to human health. And that is very much a substantive issue. I also raised...
And let me stop you there, because I want to make sure I understand. So regardless of, you're saying, even assuming they're meeting all their permit standards, that in this proceeding, we need to look at the human health impacts. Is that a correct summary of your position?
Yes, yes, because it's stated...
And on what legal basis am I supposed to be considering that? Because here's the issue. I don't have, there's no seeker review in this. This is a type 2 action. This is a permit renewal. I can't open up the whole plethora of environmental impacts that you usually get to raise in a seeker proceeding when you're reviewing a draft environmental impact statement. There is no draft environmental impact statement here. There is no environmental impact statement at all, because that was all done years ago on a renewal. It's what they call a type 2 action. And it's exempt from seeker. So I want to know, how am I supposed to be looking at
This is,
these impacts if, in fact, given the hypothetical that they're meeting all their emission standards, and yet there's a human health impact, how do I bring that into this proceeding?
Well,
Using our regulations and the environmental conservation law.
well, first of all, can you tell me what statute exempts them from SECRA? Because my reading of SECRA is that, especially in a protected agricultural district, there is no exemption from SECRA. So all state agency actions are pursuant to SECRA.
Yes, but on a permit renewal in the DEC regulations, it's a type 2 action, and it does not require seeker review, or else there would have been an environmental impact. There would have been, in our notices, there would have been provisions regarding a seeker process. And staff can address this if they wanted. It's their turn to speak, but my understanding of seeker through all these years is that renewals are type 2 actions, and
But DEC also made an announcement in January that they were going to be treating this as a new permit.
yes, and that's for the purposes of the hearing process, not necessarily the seeker process.
Well, that's very confusing to the public, because that means that it's being treated as a new permit, that it is subject to SECRA. And it's really a matter of your discretion. You do have a certain amount, you have a lot of discretion in these matters. And I do have to remind you that right now we don't have counsel, we're acting pro se. We are an organization that has been part of this process since 2012 is when we first became aware of this project. And we have engaged in every permitting process that we could since then. And we have a history and knowledge of where the process failed. And perhaps it's where that process failed that is leading to these health impacts. For example, in the DEC's, in the applicant's permit, they reject the idea of continuous emissions monitoring for particulate matter. I find that arbitrary and capricious, and perhaps may very well be the cause of these health impacts that we're seeing. We've actually been doing some amount of continuous particulate matter monitoring, and we have compiled our own data on particulate matter, even where the applicant failed to do that and chose to use 12-month averages. Particulate matter, especially particles smaller than 2.5 microns and ultrafine particulate matter, are very much an impact associated with the burning and the combustion of natural gas, much more so than larger particulate matters. And therefore, it's absolutely critical that we have monitoring, continuous monitoring. And I think what our data will show is the need to have continuous
Can I stop you there
monitoring.
with your data? Because how are you going to introduce this data?
To show the relationship between.
How? I'm asking how, not why, but how are you introducing the data?
What do you,
Who conducted the data? Who did the monitoring?
the monitorings are set up with devices that are set up at
No, I
various.
want to know who. Was it a consultant, a scientist, an engineer? Who conducted the monitoring?
The monitoring is conducted autonomously by the device. It's the whole.
And who placed that? I mean, these are all things
It was all supervised by these scientists, but they were placed at various locations throughout the region by individual members of Protect Orange County. And now we've compiled several months of data, and I think what the data is going to show is a correlation between emissions events, health impacts and high particulate matter readings. And and there are annual and hourly limits for particulate matter exposure. And I don't have the data in front of me, but I know on several occasions it exceeded those limits that are considered by the EPA to be safe for human health.
Thank you.
There are also health issues related with other criteria pollutants as well as with hazardous air pollutants.
Thank you, I've heard enough. Right now, I want to ask if the applicant or DEC staff have any responses to the petitions. I'll start with the applicant.
Well, the one-page petition that we received, we would respectfully submit, is patently insufficient to raise a substantive and significant issue. I think in the first instance, the standard to raise a substantive and significant issue is that it has to result in the imposition of a permit condition or denial of the permit. And in this case, the permit's already been denied. So I'm not sure how anyone can raise a substantive and significant issue. And really the only issue is a legal issue between the applicant and staff. It is difficult to respond to petitioner's statement today because we were completely unaware of it. The one-page petition itself just said we have hundreds of health impact reports, and that's really insufficient because it would be the equivalent of what the chief ALJ stated in Ray Finger Lake's LPG storage. You have to make an offer of proof. Any assertions that a potential party makes must have a factual or scientific foundation. Speculation, expressions of concern, general criticisms, or conclusory statements are insufficient to raise an adjudicable issue. And that's basically what the Protect Orange County petition was. I'm not prepared to respond to the rest of it today, I don't believe.
Okay, thank you. Mr. Sansa?
Excuse
Thank
me,
you.
Judge, point of order. Can we make sure people use the microphone?
Oh, yes,
You're not using
yes.
the
Please,
microphone.
let me remind you, please use the
Please
mics.
bring it closer to you.
Thank you, Your Honor. I cannot dispute that Protect Orange County has an interest in their members' health. However, I'm failing to see the connection between what they're saying today and the actual denial that is on the record here, what we're here to talk about. Again, I'm a little blindsided, as is the applicant, with what we've been presented with this morning in terms of what Protect Orange County claims is in their petition, which does not fly off the page from their actual petition here. I do have some questions related to what Ms. Malik has stated this morning, one of which is if she has these do we know what these doctors are going to testify to, who she's named for the first time here this morning? Also, you raised an interesting point, Your Honor, with respect to prior history of these people who claim to now have health issues related to the plant, which is, I guess we would be entitled to do discovery of all these people who claim to have health issues to see what their actual medical conditions were like leading up to this point, which opens up a huge, can of worms here, which is, it's not something the department would typically, a road the department staff would typically go down, is looking at people's medical records. But if that's what she's talking about, I guess that would be something you'd have to deal with moving forward. I think primarily I would just go back to the regulations and the requirements for petition 624.5 that set forth specifically what is supposed to be in a petition. And I would say that the petition that is before us today does not meet any of the requirements set forth in our regulations. And I'm wondering how we, trying to supplement it here on the record. I too cannot respond to everything that Ms. Malik has brought in for the first time. I recognize that a lot of what she's talking about were raised in the public comments that have been before the department and in the 2 legislative sessions we've had, but they're not actually part of this petition. And I don't understand the connection between the health impacts and the denial of the permit, which, as Ms. Lyson-Sider has pointed out, is actually a very discrete legal issue, not a factual issue here.
Thank you. Ms. Mallett?
First of all, I would have said that if my petition was deficient, then the applicant and the DEC staff should have objected to it. I'm representing Protect Orange County pro se. We do not have counsel, and I was under the impression that that is the very purpose of the issues conference, is to present the issues that we believe should be adjudicated. And so I think in the interest of justice and in the interest of fairness, we've got hundreds of people in Orange County that have experienced health impacts, and there should be some adjudication of whether or not that this is related to the operation of this facility. And if it is, then they would not be in compliance with their current air permit, and therefore would not be eligible for a renewal. And the scientists that we have will be able to show the relationship between the health impacts, the particulate matter monitor readings, and the emissions events that we have documented. These are all correlated. These are episodic events. And to the extent that they reveal how this plant has been operating, it has significant relevance to whether they have been in compliance with their current air permit or not. And so I would plead for the judge to allow us to raise these issues that are significant and substantive.
All right, thank you. All right, I'd like to move on to Ms. Elston's petition.
Okay,
First, Ms. Elston, I just want to confirm what constitutes your petition, because there was some confusion in all the emails, and so
sir, what?
I have what you mailed me as your petition, okay? And I know I probably state in here that there's all this other stuff that you filed. These are all the public comments you filed, and attachments there too. So I just
I'm
want
not
to.
laughing, it's just
No.
not a funny matter, but I do understand.
Right.
There was a little bit of confusion in the
I want to understand what you believe your petition is. So let's start with that, because like I said, I have what you mailed me, but then I saw the emails between you and Ms. Lichtensteiner and Mr. Sanza, where you were providing more documents, and it looked like you were providing all the public comments you had.
It was a really big confusion.
Okay, all right.
I
So,
think Mr. Sands and I were talking about, I was like, I think this went off on a different planet here.
Okay.
But if I'm being allowed to come in as a petitioner and discuss what I wrote, are you talking about the comment letter that I wrote, the technical one?
yes,
Okay.
well,
I mean, I have two different
Yeah.
things. I mean, I personally live 1.5 mile. I can see
Yeah.
the plant
okay.
from the
But I just
backyard.
wanted to confirm what constitutes your petition. So
Okay,
that was the main. Sorry.
Sticking to
Okay.
the facts,
Okay.
absolutely. First of all, I couldn't understand why there was a hearing. Because the way I read the permit, and unfortunately for 4 years I've been living with the documents from CPV, it distinctly says that they should have been filing 180 days after they were operational. So if we want to stick to the.
Because I do want to get to that.
Okay.
In like less than 2 minutes probably.
Yeah.
So I just want to confirm, you're seeking amicus status, is that correct?
Yeah.
Or full party status? Here's the difference, okay, in case.
Well, full party comes with a lot more.
Well, a full party gets to introduce evidence, bring in witnesses, cross-examine witnesses, et cetera, and an amicus party does not. They basically can submit briefs in support of somebody's position. Okay, that's the difference.
Right, so I wouldn't be able to do that myself. I would always have to be bringing in someone, or do I just bring up documents that I've dug up over the years?
When you said you would be able to do that yourself, what's that?
I mean, to be a party status, do I have to bring in like specialists, or I can just bring in the information I have on my own?
You should be bringing, your offer of proof has to be coming in through typically experts that can testify regarding whatever issue you're trying to raise. So,
I mean, I don't really, how do I say this? I find my own information, you know what I mean? It's not like I'm bringing up,
Understood.
I don't actually want to, I'm not that type of person, a little bit OCD, I stick with the facts and try and do that.
So,
So I'm not trying to dig up anything new, to tell you the truth. I'm actually trying to stick to what is already out there.
that is, okay, so I think your petition, the cover letter to it said you're seeking amicus party status.
Mhm.
Okay, so for now, let's stick with that, okay?
Okay.
Because I have questions about, that are relevant to that, but, so.
I
Let me
guess what I want
start.
to say is I want to be a voice for the people.
Okay.
I mean,
Understood.
we're all
Okay. All right.
experiencing.
Yeah, understood. But- And just a reminder, we are well past the public comment period here.
I
Now we're
understand.
trying to funnel things down through an issues conference and then
Mm-hmm.
potentially an adjudicatory hearing. Let me start with the documents you mailed to me on October 5th. And do you have a 5 unnumbered page letter you sent
Mhm.
addressed to me? Do you have that in front of you?
Yes.
Because I have questions about it, okay? Now I want to start with the third paragraph on unnumbered page 1. This goes to what you were starting to talk about. In that paragraph, you question why a hearing is even necessary. And I just wanted you to explain your position that it was assumed CPV would have been running for a year before the permit expired. I'm not sure I understand
Because
how
we
you
got
got that.
because it delayed so many different times. So ultimately, they even said they were supposed to be running way before
Okay.
the 2018. So my assumption was that this was a permit that was covering that time span, and within that time span, they were supposed to be filing for a Title V after 6 months of becoming operational. Not generational, but it says operational. I mean, if we're going to get into semantics, because that is one of the big problems with this whole project, there's a lot of semantics and syntax that is ambiguous.
And I do have a question for staff and applicant regarding operation. So thank you for your response. I now understand what your point was there. When do you believe CPV commenced operation?
You know what, I was gonna
And granted, it may be a semantic issue is what constitutes operation, but.
Well, I can tell you from where I
From your
live,
position.
I feel the plant when it starts, okay? And I can see if there's any emissions going on. So that's so I can't say the 16th because I myself did not feel it on the 16th, but I know, and from reading all the documentation, on oil, they can only run between 10 hours and 12 hours at a time. It's in their own documents. If that's different, then they can tell me or explain to me how it's different.
Right.
But I can tell you it's almost exactly 10 to
Okay,
12
let's-
hours.
Let's stick to answering your question.
Okay,
next.
sorry.
That's all right.
The 22nd.
January? Okay, thank you. Now I want to turn to your discussion of air issues, starting at the bottom of page 1 to the top of page 3. You discussed what you believe have been various problems with the review of this facility's siting and licensing. Is that an accurate summation of what you're discussing on those pages?
Yes.
Okay. Are you asking me to review what has been approved to date? Because that's kind of what I'm getting from your petition, is that you want to open up what happened in the past. So I just want to ask you, is that are you expecting me to review that?
I understand that we've been told that those things have happened and that we can't fight those situations. My problem is if there was an integrity issue from the very beginning through the secret process, and I understand this is not a secret process, but is that what is causing the issues today? But if this isn't something new, I've read everything, I know all the comments that were made by the consultants. I was not surprised that we were smelling oil. I was not surprised that we were seeing the pollutants. I was not surprised we were feeling it because of where the plant is sited. And which is why they needed to drive pilings, which was a whole nother noise issue. So within the air permit isn't just what we're talking about emissions. You have opacity, you have noise, you have all these other things that we are being affected by that I don't think were addressed correctly from day one. And they skirted those issues with the same type of syntax and semantics and ambiguous language from the very beginning. There are no definites. And I understand there aren't any definites, but them saying that they didn't have anywhere to get definites or a better prediction is false.
Thank you. You also point out, or you refer to the DEIS and point out what you believe are inconsistencies. Is that correct?
I'm sorry.
You point out what you believe are inconsistencies in the original DEIS.
Yes.
Why is that relevant? Again, same question. Why is it relevant to this proceeding?
Because a lot of it had to do with the air permits, or the air qualities, visual, and actually particulate matter. And I don't think the oil use was ever addressed properly.
Right. And that was my next question. Is you've taken a position that the permitted use of diesel was not properly addressed in the past.
Correct.
All right. Very good. Does applicant have any response to Ms. Elston's petition?
Well, we understand Ms. Elston's petition. However, the time period to challenge what was said in the DEIS, FEIS, and the whole secret process has passed. And in fact, the town of Wayanda Planning Board was the lead agency, and there was a challenge when there was an application to modify the site plan application. And the second department rejected that challenge on secret grounds. So.
May I say something?
Yes, go ahead, please.
That lawsuit was totally improperly taken care of because it didn't stick to the facts that were presented by some of the residents and the information. So just because they got skirted and it wasn't brought to the attention correctly, doesn't mean it was correct.
But I think from what I'm understanding and trust me, you know the history of this facility better than I do. But my understanding is, from what I'm hearing from Ms. Leiston-Snyder, and just when events occurred, that the time to challenge a secret determination, final secret determination in court has expired. Is that kind of what you were getting at too, Ms. Leiston-Snyder? That's irrespective of what the outcome of the lawsuit was, the time to do so was expired.
See, this is what we hear all the time, and this is what's been going on since the beginning of this project. So you see where we're coming from. I can tell you, I have tried to get an environmental attorney across the board, country, going outside the country. No one wants to touch this. So that it gives a little bit of a weird situation when I know I have a lot of the facts that everybody wants to deny going into this because of the time frame. So the problem is, for reasons that I have expressed in some of the things, we don't have a very good open meeting law in our town. So a lot of things are done under the table or behind our backs. So we didn't have time, or by the time something happened, we find out like a month later. So it's an issue, and I don't know where to bring that up.
But I understand your point. Okay.
May I say something?
Just a minute. I want to hear from
Okay.
staff. Okay. Mr. Sanza?
Sure, thank you. I would agree, obviously, that the statute of limitations period has long since gone on challenging the EIS. With respect to the petition itself, I would indicate that I don't think it actually meets the spirit of the regulations. However, I understand that if she's only seeking amicus status and she is interested in submitting briefs on the legal matters, I think she's certainly welcome to do that if they get identified down the road.
All right. Thank you. Ms. Mill?
Yeah. I mean, regarding the DEIS, I do want to point out, during my comments, I actually quoted from statements by planning board members in May of 2009 after the DEIS was issued, indicating that they were pressured by the applicant to issue the DEIS, and that they were promised that by the applicant, and this is in the record, that they would submit conduct a supplemental environmental impact statement, and they never did that. And the reason it's significant is because the DEIS is the underlying document for every single approval that has come afterwards. So there is no doubt that the review of this initial permit in 2012 relied heavily on the DEIS. And therefore, if the DEIS did not have integrity, then neither does this permit that was issued in 2012, because it references repeatedly the DEIS, statements made in the DEIS, studies done in during the time of the DEIS. When the consultants, the town consultants, after the DEIS was issued, informed the town planning board that these studies were inadequate, that they weren't complete. And I'll give you one example. There was no description, or their dispersion modeling did not account for hotspots. Now, hotspots in the kind of topography we have, there are going to be a large number of hotspots because it's actually down at the very bottom of the valley. And our several months of accumulating odor events and symptom reports and impact reports have begun to identify 2 specific hotspots. But again, this is something that CPV never did because they were able to skirt those requirements. And again, I reference this in my comment, that they did not use the Gaussian air modeling analysis, which is what they should have used, which is the industry standard, especially for a facility of this size. And I also would like to submit this as an addendum to my petition, because these are the issues that I had hoped to raise. And I can give a copy too. And this is something, Your Honor, you do have discretion over pursuant to CPLR 2004. You do have the ability to extend time or to correct any errors or irregularities. And none of the issues that I have identified are new. They were all issues that were also referenced in the public comments as well. And they're also part of the record.
All right, thank you.
Your Honor.
Yes, Mr. Singh.
First, I would note that Ms. Malik has not provided staff with a copy of whatever she's provided you and
Give you a
Ms. License Snyder. But I would like to address this issue of the EIS that keeps coming up. I would like to make clear for the record that when staff drafts an air permit, we don't base it on the EIS. We base it on a permit application and the materials that we request in the application, so that even if there was some deficiency in the EIS, which again, the statute of limitations on that is passed, it's not something that air staff looks at or considers for purposes of writing an air permit, and certainly not, it did not come into play whatsoever for purposes of the denial and the permit that's issued here.
Thank you.
Can I respond?
Please.
In the response to public comments for the air permit, DEC staff did repeatedly reference the DEIS. And I could provide you with that documentation.
Thank you.
May I?
Yes, Ms. Olson.
Wait, no, I just lost my train of thought. Okay, so the original, that's true. The original air permit was based on the DIS. However, when I did ask Chris Hogan how he had originally drawn up the air permit, he said he just did it off of the information for the type of turbines that were in the facility. He did not base it on the amount of megawatts that were being produced. So, and that is not how the air permits are done now. You have to account for the megawatts produced for the greenhouse gases and all of the other particulate matters that come out of the plants. So I don't understand how the original ASF permit could even be renewed under those conditions. It's entirely different. Now, just recently in 2017, they are finding out that these combined cycle, if they do not run at full load, which is something I brought in here, there isn't any explanation of what the full load is. And full load and the emissions from full load are lower on a natural gas plant. However, if they don't run at full load, they're actually creating more nitrous oxide and sulfur dioxide than a coal plant. And this is a recent report. So if the original air permit was only based on the type of turbine, what megawatts were they basing that on? At what type of load?
Can I just also add to what Jenna just said? In the DEIS, and this translates into the air permit as well, because the air permit uses the same emissions figures as are cited in the DEIS. One of our experts noted that CPV actually comes up with the same exact emissions estimates for operating at 100% load capacity as operating at substantially less than 100% at average levels. So according to this expert, it's not possible. You can't have the same 2.1 million tons of CO2 operating at 100% capacity as well as operating at 50% capacity. And that's never clarified at what capacity those emissions estimates are applicable at.
All right, thank you. All right, I want to turn to, I have some questions for department staff and for the applicant. So even though I think I stated this, Mr. Sansa, in my opening, I would like to get staff statement on the record, what the basis for denying the air state facility renewal permit is.
Mr. Gibbs is going to respond, Your Honor.
Thank you, Mr. Gibbs.
Yes, Your Honor, thank you. DC based its denial of the ASF renewal on a couple of factors. One, I have to find it here, sorry. The ASF pre-construction permit had an expiration date of January 31st, 2018. At that time, or prior to that time, DEC was reviewing the renewal application and determined that under the current rules, the applicable legal requirements that are applicable to the facility at that time, 201-6, the Title V requirements, required that the facility obtain a Title V permit. Therefore, the department determined that because of this requirement, we could not, as a matter of law, renew the ASF permit. Hence, we notified the applicant that we could not do that, that the application was denied, and that they needed to obtain a Title V permit in order to operate.
Thank you. I think you misspoke on the expiration.
July 31st, sorry, Your Honor. Thank you.
That's all right, thank you. Does staff believe there's any factual issues requiring adjudication regarding staff's denial?
No, Your Honor.
All right. Has there been any change in staff's position since August 1st, 2018?
No, Your Honor. However, they, for the record, the applicant has submitted a Title V permit application.
And when was that received, do you know? Or do we know when it was submitted?
Yeah,
Yeah,
August 29th, I believe, was the date.
Okay, thank you. I assume that's under review for completeness determination?
there was a notice of incomplete did go to the applicant in, I want to say September, October.
End of
And-
October.
And the applicant has submitted information in response to the notice of incomplete about 2 weeks ago, in November. And that is being reviewed because it was quite a lot of material.
Let me ask you this too, because, and this is kind of, I'm sidetracking only because I'm curious about the Title V permit application. Does EPA also review those applications?
Yes, Your Honor. Title Vs are required to go through public comment as well as an EPA 45-day review period.
Okay, thank you. Is the acid rain permit also referred to as the Title IV permit?
Yes, that's true, Your Honor.
Can the Title IV permit be issued with an ASF permit now?
The Title IV is a separate requirement, although we usually try to approve or issue the Title IV in conjunction with Title Vs or ASFs. Where it is required, there are situations where the dates aren't always lining up, but we try to issue it at the same time, since most Title Vs are required to have Title IVs addressed as well.
But I guess my question is, have the laws or regulations changed that Title IVs are no longer able to be issued with an ASF permit? If you know.
That I don't know offhand. I don't believe it's changed.
Okay, thank you. And this will be questions for both applicant and staff. Let's start with staff. Is the facility currently operating?
To my knowledge, it is operating.
Okay. Is operating a defined term in DEC's environmental conservation law regulations or permit?
It is not specifically defined. There are places where operation is referenced. In this case, usually from an air perspective or a Clean Air Act perspective, we consider operation where the facility operates a source of emissions and emissions are emitted into the ambient air.
So the reason I'm asking is, and Ms. Weissensnyder will be able to respond as well when I get to it. The reason I'm asking is because if applicant's correct and it's supposed to be within X number of, whether it's months or a year from the date of first operation, what is the date of first operation is what I'm curious about, because is it commercial operation or is it, as you're saying, first emissions? Does staff have a position on that?
Staff doesn't consider it commercial operation for our purposes because we are required to regulate any emissions from a source, and under the permit, those emission sources, specifically the ones that are listed in the permit, once they begin operation and emit, they become violations if they emit beyond those limits. So any emissions into the air have to be something that we would consider operation.
Very good, thank you. Is there, I'll throw this out to both staff and applicant. Is commercial operation more of a term used by DPS and Department of Public Service when it comes to electrical generation facilities, or?
It's used in a number of different ways, but it's primarily financing.
Okay.
DPS, the PSC just requires notice of commercial operation. It also may impact the New York Independent System Operator, although they note when the facility first starts generating. But they also want to know when you achieve commercial operation.
All right, very good, thank you. That clarifies that a little bit for me. Thank you. If department staff's denial of the airstate facility permit renewal is upheld by the commissioner, what relief is staff requesting? Do you want a commissioner's order that shuts down a facility, or that's?
I'm sorry, I'm not prepared to answer that again. I'm not expecting that question.
It's all right. If you were to, Mr. Sands, if you were to frame what the legal issues are that need to be addressed, what would the question be?
Your Honor, our question would be, as a major facility, is CPV required under 6 NYCRR subpart 201-6 and ECL 19-03111A to obtain a Title V operating permit from the department in order to authorize operation of its power plant.
Thank you. Applicant raised in their letter requesting the hearing the fact that they're entitled to a SEPA extension pursuant to SEPA 4012 and 6 NYCRR 62111L. The staff have a position regarding that?
We do.
Yes, Your Honor. Thank you. The question of whether the CPV's ASF permit was extended by SAPA 401 and 6 NYCRR 62111 is, in this case, our position is no, not in this case. Although those provisions normally would extend a permit, if the facility owner meets certain requirements under those provisions. Those regulatory provisions authorizing operation of CPV's facility under the ASF permit were repealed in 2013. Since the ASF permit no longer meets the applicable legal requirements for continued operation, SAPA could not, as a matter of law, extend the ASF permit, and DEC could not grant a renewal of the ASF permit.
Thank you. I want to make sure I have this right. So we have an ASF permit that expired July 31st of 2018. The renewal application is received in mid-January, mid to late January. Staff does not deny the renewal application until a day after the permit expires. I'm kind of taken aback by that. Is there a reason for this, or is it just, it took staff that long to finally respond to the renewal application?
I think it's fair to say it took staff unusually long to get back to them on it, yes.
Thank you. All right, Ms. Leisensnyder, I'll ask you the same question. Does CPV believe there are any factual issues requiring adjudication regarding the denial?
No, Your Honor, CPV does not. It's a legal issue between staff and the applicant, and I believe Mr. Sands has correctly stated what the legal issue is.
Okay, so that was my next question for you was, is the legal question that's presented by staff, you think that's a...
It's a fair statement.
Fair statement? Okay, thank you. And I think we already covered when they commenced operation, and I'll explain the difference between commercial versus just operation to me. Appreciate that. Is the facility currently operating at full capacity, do you know?
As far as I'm aware, yes, unless there's something that needs to be prepared.
And they're operating on natural gas now?
Yes.
May I say something, please?
Not yet, thank you.
Oh.
I think I have everything. Yes. I think I need the applicant's position regarding some of the questions to staff. So go ahead, Ms. Mallett.
No, it's me.
Ms. Essen, I'm sorry.
Well, how do we prove that the plant is running at full capacity?
I'd have to check with my client as to the exact
I can tell you
level of
right now,
operation.
when that plant is running at full capacity, you can hear it. Well, actually, I can hear it right now in Goshen. That's how far you can hear it, and they're not running at full capacity. When all of those turbines are running at high speed, you know it. Everyone in this county knows it. I do not think that they are running at full capacity. That is my opinion, but I used to work for Siemens and I used to work with turbines, and I'm pretty sure they're not running at full capacity. I can tell you when they are, when they're starting up and when they're shutting down, you can hear those turbines.
Right.
So I don't, this is what I'm talking about, ambiguous.
I know.
How do we know
Okay.
if they're running at full capacity or full load?
It's more of my curiosity. It's not really relevant to what we're talking about today, but it was just more of my curiosity to try to figure out what's going on with the facility. I have questions. I have further questions for applicant and staff. So,
Okay.
Let me finish. Okay. Thank you. I have 3 areas of concern that were raised regarding comments that were raised in the public comment hearing, and I'm inclined to inquire further. I've heard the comments from the public, from the local legislators, from Ms. Malik, Ms. Elston here today again, and there's 3 topics that if applicant staff choose to respond to what have been public comments, they can today. If you choose not to, I'm not going to hold it against you. They're just things that I want to inquire about, okay? One is the character and fitness of the applicant. The second is the noise produced by the facility. And the third is the emissions. So if staff or applicant want to respond to what we've heard for, during 2 public comment sessions, as well as all the public comments we received via email, which I've shared with everybody, as well as the ones that I've scanned in that I received in the mail. These were the 3 topics that resonated constantly through most of the comments. I don't want you to talk about frac gas because I don't have any control over any of that. But, like I said, if applicant or staff choose to respond today to what they've heard from the public comments, I'd be glad to hear it. Thank you.
Thank you, Your Honor. I have no comment about your first area of concern, character and fitness of the applicant. Certainly not prepared to make any comments about that. With respect to noise, I suspect the town has a noise ordinance. Obviously, DEC has a noise policy. If there's some ongoing issue with noise that these folks have, obviously it's unrelated to the air permit. I guess they could contact the town about that. But
Yeah, let me ask you this, because the town of Wayanda sent a letter to us in part of their public comments, where the town attorney is claiming that the DEC issued permits for this facility that requires CPV to continually be assessing and mitigating noise impacts. And I looked through the ASF permit. I saw nothing in there regarding noise. So I don't know. Do you know what the town of Wayanda is speaking to?
I do not, Your Honor.
Okay, thank you.
And then lastly, with respect to emissions, obviously that is related to the air permit. And so that is something that we would directly do regulate with respect to this facility. So it would be something that going forward in the review of the Title 5, Title 4 permits, that would be addressed.
As far as complaints that have been received to date, has the region been receiving complaints regarding noise or air emissions? And if so, has there been any monitoring or investigation going on?
I have to say I'm not completely prepared to answer that. I know the regional office had received complaints and they did conduct some investigations. I don't have the details at this time to say when or where or what the complaints were, but I believe there were.
Okay. And I understand I'm kind of putting you on the spot because we don't have regional staff here, so, okay. Ms. Snyder?
Well, with respect to emissions, Your Honor, I don't believe there's been any allegations that CPV is currently violating the terms of its permit limits, which are based on the National Ambient Air Quality Standards, which are health-based standards. With respect to noise, the town does have a noise ordinance, and as part of the final environmental impact statement, there was a noise complaint protocol agreed to between the applicant and the town, which is being followed.
Is there like a hotline set up or something for?
Well, if there's complaints, the town takes them to CPV, They agree on a monitoring protocol, and they undertake noise monitoring, which is what's being done. And in terms of the character of the applicant, I'm not sure specifically what you're speaking to, because there's a whole bunch of different allegations.
Right, no, I'm talking about the stuff that's occurred in the federal courts.
Well, Your Honor, I would only point out that Mr. Kelly pled guilty to lying to CPV, and he's ordered to pay restitution. He was found to have perpetrated a fraud on CPV, and he no longer works for them.
May I respond?
Please, go ahead.
I was at the Particulate trial every single day, and trial testimony indicated that company executives at the highest level, the president of the company, facilitated the bribery scheme. And in an email, and I'm quoting the email, when one company accountant complained about the payments and the way the payments were being issued, the president wrote back and said, quote, "Let Kelly do his job," which means that the company facilitated the bribery scheme. And if you go back and look at the history of this company, the way they evaded public participation, the way they failed to notify people living within the 5-mile radius, you will see a pattern of evasion, a pattern of obfuscation. The linguistic semantics games that they play are routine in all of their permitting applications. For example, they know very well that they are supposed to apply for a Title V permit. They have stated it in their own filings and in their own statements. And now they come here and pretend like, you know, they don't believe they have to. That's not accurate. That's not what the record shows.
I think the record shows that I had before me is that there's a disagreement as to when they had to file the Title V.
It's very clear in their own statements. It's within 180 days of starting operations. And as I said, we documented that they started operations on January 16th. I also want to respond to the issue of noise. There's also a health impact to noise, and the World Health Organization has deemed that exposure to decibels of 40 and or above is harmful to human health. We have measured, now the town noise ordinance is 65 decibels 100 feet from the source of the noise. It should not be greater than 65 decibels. We have measured it at 11 o'clock at night, at 1 o'clock in the morning at 76 to 80 decibels. And this is hundreds of feet from the facility. So they're clearly in violation of the noise ordinances. And as Jenna says, when they operate at full capacity, everyone can hear it throughout the county. It is that loud. What's the third issue? Was the emissions? Right. Well, you know, the emissions, again, how can you, this is the problem with the original air permit. How can you ensure compliance when you're actually not even measuring? So they don't measure for particulate matter. They average out and estimate. Even for all of the other criteria pollutants, they only want to measure intermittently. They don't want to do any continuous monitoring. And again, you know, as Jenna explained, nitrous oxides and particulate matter go hand in hand, because depending on how much ammonia is used, you can either increase the amount of nitrous oxide emissions, or the converse is that you then increase the amount of particulate matter emissions. And in order to get that formula right, you have to be measuring both, which the company doesn't want to do. And once again, I submit that measuring of particulate matter, especially 2.5 or smaller, is absolutely critical in ensuring compliance with both federal and state air quality regulations.
Thank you.
Could I just add one
Yes.
more point on the character of the applicant? I would point out there was no allegation in the federal court trial that anything affected the permit process here. There's been no allegation that the permit process was affected by the actions taken during.
Right. Thank you.
Can I say something?
Very, very briefly, please.
Just because there isn't an allegation doesn't mean that there isn't a connection.
All right, thank you. I'm gonna put staff on the spot again. If and when the Title V application is determined complete, and it's put out for public comment, you know, I'm assuming there'll be at least a legislative hearing on the Title V application, is that correct?
Yes.
There'll be a public comment hearing. Okay. There's no guarantee, though, that the Title V application will be referred to the Office of Hearing and Mediation Services to conduct further proceedings. Or does staff believe there's going to be such interest that they're going to have to refer it over for?
I think it would be premature at this point, or since staff hasn't even completed its review of the materials that it's requested.
I told you I was putting you on the spot, so. All right. I don't have any further questions today. Moving on from here, once I receive the transcript and I share the transcript with the parties and the petitioners, I will be drafting preparing a written ruling to determine whether the petitioners are granted party status, and if there's issues to be joined, what those issues will be. I guess my question to department staff and applicant is, do the parties want an additional opportunity to brief their legal question after the ruling? Or do you want me to decide the legal question as part of this ruling?
Staff would definitely want the opportunity to brief the legal issue, or legal issues to the extent there are, that are identified in any issues ruling, Your Honor, yes.
Okay. Ms. Hutchinson?
The applicant would like an opportunity to brief the legal issues.
Okay, and if Ms. Elston was in either of the parties granted party status, then they would also be able to join in on the briefing. Okay, very good. That makes sense. I just wanted to get your positions on that. So, any questions about how things are going to happen moving forward? It's probably going to take 3 weeks or so, a little better to get a transcript. So that puts us into the holidays. So then I have to prepare a ruling. We're probably looking at definitely after the first of the year before anyone can be expected to see a ruling. Okay?
Does that mean they're still running until then?
That means they're still running. Yes.
Well, that's as a result of the
There's a court order
Right.
that allows them to continue operation until there's a final determination here. Okay?
And all further appeals have been exhausted.
Right. Yeah. So, because if I rule in, also just so you know procedurally, no matter how I rule, the parties and the petitioners can always appeal my ruling to the commissioner. And what I'll do in that ruling is I will set up I will probably provide dates if there's to be any appeals, dates for those appeals to be submitted to the commissioner. Okay?
I have a question. If
Sure.
CPV has submitted a Title V application, does it obviate this proceeding?
No, because, I mean, right now, that will happen, I mean, even if if I ruled on this today and it was final, there would still be this Title V application sitting there, it's gotta be considered by the department. So, what I have before me is the denial of the ASF renewal permit. I don't have that Title V permit before me. It has not been deemed complete, it has not been put out for public comment, it has not been referred to the Office of Hearings and Mediation Services. So, that will run its own course eventually. I'm assuming. I can't speak on behalf of staff and applicant, but I'm assuming that will run the course that Title V permit applications typically run. So what I'm dealing with right now is the denial of a renewal. And so if this was, again, if the Title V permit application went through the whole 624 process again, the Part 624 process, it means you will be back here again, raising your issues, and I'm assuming there's going to be some Title V permit, there's going to be some secret review in the Title V permit. So I can't speak for staff, staff makes that determination, I don't. So that Title V is running separately from what's going on here today and in the near future. So, did I answer your question?
But you did say there's gonna be a public comment period on the Title V. So we
If
can.
it ever gets to a completeness determination, yes, it will. Okay.
But are you saying that if it doesn't, then they could just continue to operate on an ASF permit? Is that-
What I'm saying is they will work, the applicant's gonna work to get a completed application, so it'll eventually get complete. All I'm saying is, we don't know what tomorrow brings. If a company decided to just say, shut down, close their doors and walk away from a permit application, they have the choice to do that. I don't see that happening here, but I'm not gonna speculate as to what's gonna happen in the Title V. Because that's not before me, I've never seen the application, I may not ever see it, it may not be assigned to me in the future, I don't know, so, okay. Any other procedural questions?
Yeah, Your Honor, the applicant would like to object to having this handed up at the issues conference.
The
Addendum to
Okay,
party
all right.
status.
And both staff and applicant have copies now?
We do now, Your Honor.
Okay, thank you. All right. Anything else? All right, hearing nothing, we are adjourned. I thank you, everybody, for your time and energy. Thank you to the public for coming. So, thank you very much. We are adjourned.
Do you want a copy of the copy of the
Oh, yes, please.
Another